July 15, 2025. Florida takes down another criminal in its death chamber. Michael B. Bell spent more than 30 years on death row, fighting with all his might to avoid the death sentence. A ray of hope shone through appeals and witness recantations. But were they strong enough to cancel the court's final verdict? This is a tale of revenge and rage. Join us as we dive into the events that led up to Bell's execution, his last meal, and his last words. Michael Bernard Bell, State, Florida, date of execution, July 15, 2025. On December 9, 1993, Michael Bell shot and killed Jimmy West and Tameka Smith outside a liquor lounge in Jacksonville. Two major eyewitnesses testified about the murders. They were Henry Edwards and Charles Jones. The trial court described the events in its sentencing order. Earlier, in June of 1993, Theodore Wright killed Lamar Bell in a shootout. The court ruled that Wright's actions were justifiable as self-defense. Michael Bell vowed to take revenge for his brother's death. Over the next 5 months, Bell repeatedly told friends and family that he planned to kill Wright. On December 8, 1993, Bell bought an AK-47 assault rifle, a 30-round magazine, and 160 bullets through his girlfriend. The next night, Bell spotted Theodore Wright's car, a yellow Plymouth. Bell left the area and soon came back with 2 friends and his rifle loaded with 30 bullets. After a brief search, he found the yellow car parked outside a liquor lounge. Bell did not know that Wright had sold the car to his half-brother Jimmy West. West had parked the car and gone inside the lounge. Bell waited in the parking lot until West left the lounge with Tameka Smith and another woman. Bell grabbed the loaded AK-47 and walked towards the car just as West got into the driver's seat and Smith entered the passenger side. Bell approached the open driver's side door and, at point-blank range, fired 12 bullets into West and 4 into Smith. The other woman ducked and escaped without injury. After shooting West and Smith, Bell fired many bullets into the front of the lounge, where about a dozen people were waiting to go inside. Bell then drove to his aunt's house and told her, "Theodore got my brother, and now I got his brother." Bell was charged with 2 counts of first-degree murder. At trial in March 1995, Bell pleaded not guilty because of self-defense, stating that he believed West had reached for a weapon just before Bell began shooting. The defense presented no evidence or witnesses. A jury found Bell guilty of the first-degree murders of Smith and West and unanimously recommended the death penalty for both murders. During the penalty phase, a lounge security guard testified for the state that he and 7 or 8 other people were in the line of fire and hit the ground when Bell sprayed bullets in the parking lot of the lounge. He also testified that Bell shot 4 or 5 bullets into a house next door, where 3 children were inside at the time. The state introduced a copy of a record showing that Bell was convicted of armed robbery in 1990. Also, during the penalty phase, Bell's mother testified for the defense that she and Bell had received death threats from Wright and West. She testified that Bell was in good mental health and gainfully employed, and that she believed he did not commit the murders. In a single sentencing order covering both homicides, the court followed the jury's unanimous recommendation and imposed death sentences, finding 3 aggravating circumstances and 1 marginal statutory mitigating circumstance. Firstly, Bell had previously been convicted of another capital felony or a felony involving the use or threat of violence, prior violent felony. The second issue was that the murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification, CCP. In committing the murders, Bell knowingly created a great risk of death to many people. The trial court also found 1 marginal statutory mitigating circumstance, that Bell was under extreme mental or emotional distress at the time of the murders. Regarding his second issue, Bell argued that the trial court made a mistake by deciding the murders were committed in a cold, calculated, and premeditated CCP way. Bell claimed the CCP aggravators should not apply because the prosecution used two different theories: transferred intent and quickly formed, premeditated intent to kill West. He said the aggravator could only logically apply to the transferred intent theory. Second, Bell argued that the killing of Smith was accidental with no transferred intent, so her death could not be considered cold, calculated, and premeditated. Third, Bell claimed he shot in self-defense, which gave him a moral or legal justification for the shooting. However, the state disagreed with all three of these claims. The state proved that Bell had a prearranged plan to kill. Cold, calculated, premeditated murder was shown by circumstances such as the advanced procurement of a weapon, the lack of resistance or provocation, and the appearance that the killing was carried out as a matter of course. A review of the record revealed that Bell told several people he planned to kill Theodore Wright and purchased a gun for that purpose. Although West and Smith were not the direct targets of the plan, this fact did not prevent a finding of cold, calculated premeditation. The focus of the CCP aggravator was on how the killings were carried out, not on the specific targets. Furthermore, there was no valid claim of legal justification based on self-defense. Therefore, the record contained competent and substantial evidence supporting the finding that the murders were cold, calculated, and premeditated without any pretense of moral or legal justification. Accordingly, the court held that the trial court did not err in its finding of the CCP circumstance. In his final issue, Bell argued that the trial court erred by failing to consider and find mitigating circumstances properly. However, this argument was rejected. The sentencing court was required to explicitly evaluate each mitigating circumstance proposed by the defendant in its written order, but the decision on the weight given to each mitigating circumstance was within the court's discretion. The state's review of the record showed that the trial court did not abuse its discretion in assigning only minimal weight to the statutory mitigating circumstance of extreme mental or emotional disturbance and in finding no evidence of non-statutory mitigation. Bell presented no evidence during the guilt phase of the trial, and only his mother testified during the penalty phase. The trial court properly examined the record for mitigation, including a competency evaluation, and weighed the minimal mitigation it identified. Based on the record and the evidence presented to the trial court, no error was found regarding the court's findings or its weighing of mitigating circumstances. In conclusion, the state found no error affecting the judgment or sentence. The state also determined that the death sentences were appropriate. Therefore, the convictions and sentences were affirmed. Bell later filed a motion for post-conviction relief. However, in December 1999, the circuit court summarily denied the motion. Bell appealed the denial to the Florida Supreme Court. After holding oral argument, the court reversed the decision and sent the case back for an evidentiary hearing. After that hearing, the circuit court again denied relief. Bell appealed the court's order and also filed a petition for a writ of habeas corpus. The Florida Supreme Court affirmed the denial of post-conviction relief and also denied Bell's habeas petition. In the years that followed, Bell filed several additional post-conviction motions. He also sought relief in federal court. In 2017, a motion for permission to file a successive federal habeas petition was denied. On June 13, 2025, Governor Ron DeSantis signed Bell's death warrant and set his execution date for July 15, 2025. On June 18, 2025, Bell filed a successive motion for post-conviction relief in the 4th Judicial Circuit, raising 4 claims. He requested an evidentiary hearing only for the first claim, which involved allegations of newly discovered evidence in the form of Brady and Giglio violations. Following a Huff hearing on June 20, 2025, the Circuit Court granted an evidentiary hearing on the newly discovered evidence claim. Bell raised 4 issues in his latest post-conviction appeal. The first 2 focused on his claim that during the investigation and prosecution of his case, Detective William Balena, now deceased, and Assistant State Attorney George Bataille engaged in a pattern of misconduct involving several witnesses. Bell argued that this misconduct led to false testimony being presented in violation of Giglio and the withholding of evidence that could have helped his defense or challenged witness credibility in violation of Brady. He further claimed that the witness statements exposing this misconduct amounted to newly discovered evidence. In the first issue, Bell challenged the Circuit Court's decision to allow several witnesses at the evidentiary hearing to invoke their right against self-incrimination. Henry Edwards, Charles Jones, Dale George, and several others, all of whom had testified for the state at trial, invoked the Fifth Amendment during their testimony as defense witnesses at the June 23 evidentiary hearing. Charles Jones, in particular, refused to answer most questions and repeatedly invoked his right against self-incrimination. Bell argued that allowing these witnesses to invoke the Fifth Amendment prevented him from developing additional, newly discovered evidence. Specifically, he claimed it blocked him from uncovering information related to alleged misconduct by police and prosecutors, as well as potential grounds to impeach key trial witnesses. By the time of the evidentiary hearing on June 23, 2025, all 5 witnesses had already testified at Bell's original trial and his 2002 evidentiary hearing. Just days after Bell's death warrant was signed, both Edwards and Jones signed affidavits in which they claimed to recant parts of their trial testimony. While Williams, Pryor, and George declined to provide affidavits, they did speak with Bell's investigators. According to Bell, the information they shared led him to amend his successive post-conviction motion. In the second issue, Bell contested the court's denial of his claims related to the newly discovered evidence. In the third issue, Bell argued that the combined effect of alleged witness recantations and threats of perjury denied him fair and reliable proceedings. Bell's successive post-conviction motion, filed on June 18th, alleged that 2 key witnesses, Henry Edwards and Charles Jones, had recanted significant parts of their testimony from the 1995 trial. During the evidentiary hearing, one of Bell's federal public defenders, Tenny Martin, testified about how the new information came to light. She explained that shortly after Bell's death warrant was signed, she received a call from Linda McDermott, a fellow federal public defender working in another region. According to Martin, McDermott informed her that her investigator, Dan Ashton, might have recently come across information relevant to Bell's case while working on a different investigation. Ashton had reportedly spoken with individuals who turned out to be witnesses in Bell's trial. After further coordination and outreach to Bell's post-conviction attorney, Robert Norgard, 2 federal investigators met with Edwards and Jones. They obtained signed affidavits from both men in which they recanted key portions of their original trial testimony. Number 1, Henry Edwards. At trial, Henry Edwards testified that he met Michael Bell at a neighborhood establishment and saw him often over the next 6 months. On the night of the murders, Edwards claimed he was standing outside the liquor lounge when he saw Bell pull a ski mask over his face and reach into the back seat of a car. Edwards said Bell walked toward him holding a rifle with a magazine, then changed direction and began firing into a nearby vehicle. Edwards testified that he saw only one gunman. In 2002, during Bell's initial post-conviction hearing, Edwards reaffirmed this testimony. However, on June 16, 2025, Edwards gave an affidavit recanting that testimony. In the affidavit, Edwards claimed he had been inside the liquor lounge during the shooting and only heard gunfire. He did not see the shooter. He stated that Detective William Balena knew Edwards hadn't seen the shooter and that Balena shared details of the case with him. Edwards also said that Balena did favors for him, including transporting him from jail and arranging family visits. Before the trial, he had only seen Bell twice. During a photo lineup, Balena allegedly pointed out Bell to him. Edwards further claimed that Balena placed him in a holding cell with another witness who described the murders to him. He said he felt intimidated by Balena, that the prosecutor coached him on what to say in court, and that he was promised a lighter sentence in his case in exchange for his testimony against Bell. The affidavit also stated that another investigator had previously questioned Edwards about Balena's conduct. Although he wanted the truth to come out, he would not have spoken up if Bell's legal team hadn't reached out to him. However, at the evidentiary hearing, Henry Edwards denied the truth of the affidavit he had signed just days earlier. While he acknowledged that he had worked as a confidential informant for Detective Balena and that Balena had approached him in jail after learning Edwards had been at the scene of the shootings, Edwards walked back his earlier claims. He admitted that before Bell's trial, "I might have seen him one time, but I didn't know him." Yet, contrary to the affidavit, Edwards testified that he had been outside the liquor lounge on the night of the murders. When questioned about this contradiction, Edwards admitted to signing the affidavit but said it wasn't true. He claimed he had not written or read the affidavit before signing it. Edwards further testified that he believed the investigators were making a movie about Bell and that he signed the affidavit to help Bell, who was facing imminent execution under a death warrant. Given Edwards's reversal and the inconsistencies in his testimony, the circuit court ultimately denied Bell's claim. Number 2. Charles Jones. Bell also pointed to the alleged recantation by Charles Jones. At trial, Jones testified that he had known Bell for about 10 years. A few days after the murders, he said he saw Bell acting nervously and trying to sell an AK-47 for less than what Jones believed was its street value. According to Jones, Bell lowered the price to get rid of the gun, but still could not find a buyer. Weeks later, Jones claimed he had asked Bell why he had killed Jimmy West. Bell allegedly replied that he did it because Wright had killed his brother, Lamar Bell. Bell also said that Tameka Smith was simply in the wrong place at the wrong time. Detective William Balena later visited Jones in jail after Jones had pleaded guilty to a separate federal charge. Jones said he shared the events with Balena and a few weeks later gave a sworn statement to the state attorney's office. At the time of his trial testimony, Jones was awaiting sentencing in his federal case. There was no formal plea agreement, but he admitted he hoped the judge would consider his cooperation in Bell's case. On cross-examination, Jones admitted he did not like Bell and that they had past disputes. He reaffirmed his trial testimony during Bell's 2002 evidentiary hearing. On June 18, 2025, investigators spoke with Jones and obtained an affidavit. In it, Jones stated that Bell never tried to sell him a gun, never confessed to the shootings, and that both Detective Balena and the prosecutor had coerced him into testifying against Bell. He also claimed they promised a reduced sentence in his federal case, and that the prosecutor threatened him with more prison time if he changed his story during the 2002 hearing. Finally, he revealed that his sister was in a relationship with Detective Balena at the time of the murders. Bell argued that this new information should be considered newly discovered evidence and that it showed violations under Brady and Giglio. He said it created reasonable doubt about his guilt and the finding that the murders were cold, calculated, and premeditated. Bell claimed the affidavit would have cast doubt on the police investigation and, by extension, the state's case. However, the court disagreed. At the evidentiary hearing, Jones confirmed he had signed the affidavit. However, he invoked his Fifth Amendment right against self-incrimination and refused to answer most questions, especially those about the affidavit's content. The court explained that because Jones did not testify to any part of his alleged recantation, there was no way to assess the credibility of his new claims. Like the Edwards claim, the court ruled that this failed to meet the burden of proof. Therefore, the court denied this part of Bell's motion. Number 3. Dale George. At trial, Dale George testified that Michael Bell held a grudge against Theodore Wright for killing Bell's brother. On the night of the murders, George rode with Bell to a liquor lounge, while Ned Pryor followed in a separate car. Once there, Bell pointed out Wright's car. Sensing danger, George urged Bell to leave, but Bell refused. Bell parked, pulled a ski mask over his head, grabbed an AK-47 from the back seat, and got out of the car. As Bell walked toward Wright's vehicle, George moved into the driver's seat. Moments later, George heard gunfire. Bell returned, firing more shots toward the lounge before jumping into the car. George then drove back to where his car was parked and left Bell to drive off alone. Later that night, George received a page from Erica Williams, Bell's then-girlfriend. He went to her apartment, which she shared with George's then-girlfriend. When he told Williams that Bell had just shot up Theodore Wright outside the lounge, she didn't believe him, so George took her to the scene, then drove her back home. While there, Bell called Williams and asked her to bring clothes to his aunt's house. George refused to take her and left. Detective William Balena first questioned George months later. George initially denied knowing anything, but after Balena revealed details of the case during a second meeting, George gave a sworn statement to the state attorney's office. Days later, he accepted a plea deal for accessory after the fact. In exchange for his cooperation, George faced no more than 5 years in prison. He had not been sentenced at the time of Bell's trial and reaffirmed his testimony at Bell's 2002 post-conviction hearing. In Bell's amended motion for post-conviction relief, he alleged that George told investigators he had been threatened with first-degree murder charges if he didn't testify against Bell. George also reportedly said that Balena physically assaulted him while he was handcuffed. However, George refused to sign an affidavit confirming this. At the 2025 evidentiary hearing, George denied ever saying he had been threatened and invoked the Fifth Amendment for most other questions. The court found that Bell did not prove George was coerced into testifying. The judge also found no evidence that the state knowingly used false testimony from George. Finally, in the fourth issue, he challenged the timeline set for his execution under the death warrant. Bell contended that the time specified in his death warrant was unreasonably short, and that, given the circumstances of his case, he was deprived of proper notice and an opportunity to be heard. However, this claim lacked merit. The court reviewed not only the allegations presented in Bell's June 18th motion, but also those included in the amended motion filed the night before the hearing. The court also reviewed an additional claim raised during the hearing itself. The circuit court noted that Bell had not identified any matter on which he had been denied notice and an opportunity to be heard. Furthermore, the court had recently considered and rejected similar challenges to the time set in death warrant cases. Bell requested that the court stay his execution and hand down jurisdiction to the circuit court for a new evidentiary hearing. After fully considering Bell's motion and the issues raised in this appeal, the court found that Bell had failed to demonstrate substantial grounds upon which relief might be granted, and therefore no stay was warranted. The defense called several other witnesses from Bell's original trial who were also interviewed again after his death warrant was signed, following new investigative leads. One such witness was Paula Goins, Bell's aunt. At trial, she testified that she heard Bell tell his girlfriend, "Theodore got my brother and now I got his brother," implying revenge. However, during the post-warrant interviews and questioning by Bell's attorney, Robert Norgard, Paula struggled to recall details. She couldn't fully remember that traumatic day, which she said she tried to block out. Paula did recall Bell saying, "We did it," referring to another man being involved, rather than claiming sole responsibility. When asked about any pressure from Detective Bolena and Prosecutor Bate, she refused to say they threatened her, but admitted they persuaded her, making her feel very uncomfortable. Specifically, she was told she could face up to 5 years in prison if she refused to testify. In addition, Goins revealed that she has been threatened by one of the victims' families, even on social media platforms like TikTok, simply for appearing in court. Bell's girlfriend at the time, Erica Williams, mirrored the pattern of other witnesses by repeatedly pleading the fifth or claiming she didn't recall any details about Detective Bolena and Prosecutor Bate's tactics, even regarding conversations she had just a week earlier with Investigator Kelly and mitigation specialist Christy Dickerson. She did, however, confirm that she was terrified when officers came to her home back then and told her she had to go downtown for questioning. She spent 13 to 14 hours locked in an interrogation room where officers yelled at her. Yet, when asked if she was threatened, she again invoked the Fifth Amendment. During cross-examination by Mizrahi, Williams' only response was, "I don't recall." One of the final witnesses to testify was Kathy Robertson, who was married to Henry Edwards at the time. When questioned about whether Edwards acted as a confidential informant for Detective Bolena, she cryptically replied that they had dealings. Robertson also revealed that Bolena occasionally brought Edwards to visit her while he was still in jail, and even gave her cash to help out. 2 other felons who were jailed at the time and had previously testified against Bell gave similar answers, either claiming a lack of memory or pleading the fifth. When questioned about their original testimonies and their recent discussions with Kelly and Dickerson concerning the actions of Bolena and Bate. Following this, the court affirmed the denial of Bell's successive motion for post-conviction relief. It denied his motion for a stay of execution as well as his request for oral argument. The court further stated that no rehearing would be entertained and the mandate was to issue immediately. On July 15, 2025, Michael Bernard Bell was executed by lethal injection at the Florida State Prison in Rayford. If you enjoy the way we create videos and would like us to bring more cases like this to light, please hit the like button and subscribe for more in-depth dives.